We have two wonderful speakers today. First is Deepak Gupta, founding principal of Gupta Wessler, where he focuses on Supreme Court, appellate, and complex litigation with an emphasis on consumers' and workers' rights, class actions, and constitutional law. Deepak has been described as one of the emerging giants of the appellate and the Supreme Court bar. This October, he is set to argue before the Supreme Court in two consolidated cases on personal jurisdiction. And I should just add, most importantly, he's a proud member on the AFJ Board of Directors. Julie Murray is staff attorney at Planned Parenthood Federation of America, where she represents the Federation and Planned Parenthood affiliates around the country in litigation to protect and expand access to comprehensive reproductive health care, including abortion. She's handled public interest cases for more than a decade. Julie is currently lead counsel in a case brought by abortion providers to challenge a Texas executive order barring certain surgeries and procedures permitted during the COVID-19 pandemic. Based on enforcement threats, that order forced doctors to stop providing nearly all abortions in the state of Texas. Let me lay out the logistics, which are pretty simple. We will take audience questions in the last 15 minutes, and as you come up with them throughout the call or during the question and answer period, please submit them by email to rachel@afj.org. Again, it's rachel@afj.org. Before we start, I'd just like to ask Deepak and Julie, just very briefly, on a personal note, how you're managing your work life and how you both have adjusted to new routines. I think we're all figuring that out as day by day. Deepak, you want to answer that first, and then we'll go to Julie.
Yeah, and thanks, Nan, for putting this together and for Alliance for Justice for organizing it. I think the world has changed so quickly in the last few weeks, and it's great to be able to kind of take stock of how it's changed. I'm kind of taking it day by day. I'd be curious if Julie had the same experience, but when I was very intensely working on a Supreme Court case, kind of at the beginning of the whole shutdown of the stay-at-home world that we've now gotten used to, it was helpful to have something to focus on. And it was after I filed the brief and had a little downtime that I really began to realize how much this has completely changed our lives. I mean, we're fortunate, of course, that we do work that we can do from anywhere, from home, and so we have our jobs, we have our health, and there are a lot of other people for whom this has been so much more disruptive. But it has been really weird, and I was supposed to be arguing before the Supreme Court about a week from now, and now that's been pushed to October. The court is going to experiment with arguments by telephone, and nobody knows how that's going to go or how to prepare for it. So it's really it's a whole new world, and I'm just trying to stay sane.
Julie, what about you? Thank you, Deepak.
Yeah, well, to start, I should say thank you so much for having me. I'm excited to have the discussion tonight and get out of our repro rights frame a little bit and be with all of you. I think I would echo what Deepak has said. I think certainly my family and I feel very fortunate right now and are lucky enough to be able to do our jobs from home. But I do think it's a weird time to be, dealing with some of these issues in your professional life and the litigation that we're currently doing, but also, in your personal life dealing with the fallout from the COVID-19 pandemic. You may, hopefully not, but you may hear my 5-year-old and 2-year-old screaming in the background at some point. And that has basically been the days recently, as I know I and many of my colleagues are working, extreme hours right now to deal with state restrictions on abortion during the pandemic. We're also, many of us, dealing with a full house and lots of other responsibilities that come with that.
Well, thank you both for what you are doing. And let me just introduce this session by saying at the outset, I think it's important to point out that during almost every crisis in American history, our Constitution, laws, and values have been challenged, from when we saw Japanese Americans being interned during World War II. We saw the Bush administration's war on terror and use of torture. We're now facing an unprecedented health and economic crisis that has already completely changed our nation. Local officials have exercised broad police powers to keep us safe, and a president who has already demonstrated his contempt for the rule of law over the past 3 years, has only gotten more and more brazen about unchecked power. On Monday, Trump argued that, quote, when somebody's president of the United States, the authority is total. And that's the way it's got to be. It's total, close quote. I would ask you what are you seeing as this pandemic unfolds with respect to not only the Trump administration, but states using the pandemic as a pretense to limit rights and freedoms? Deepak, can you comment on that first?
Sure, yeah. I mean, I think, we all know how the pandemic has changed our everyday lives, our personal lives, our work lives, maybe the health and well-being of people we know. But I also think it's very quickly changed the relationship between the individual and the state. And we all expect that the government is going to be able to protect us in a pandemic and is going to, be able to do extraordinary things to do that. And I think that's part of the social contract. And that entails necessarily, some restriction of individual rights in the name of the collective good, in the name of public health. And that's not new. That's happened, in previous epidemics, previous public health problems in American history. And so, maybe we have a little bit of a constitutional vocabulary to talk about it, but it's pretty new, and it really hasn't happened to anything like this degree in at least 100 years. And so, it surprised me how just in the past few weeks, how the issues that have arisen kind of span the full gamut of civil rights and civil liberties and constitutional issues, everything from, as you mentioned, Nan, basic questions about presidential power and federalism, to voting. How do we do elections in a pandemic? And that was the first COVID case to reach the Supreme Court, the one about the Wisconsin elections. Just this afternoon, there was a preliminary injunction issued in Texas about voting by mail. There are big questions about what constitutional rights can be restricted by the stay-at-home or business closure orders. I've been working with some local jurisdictions that have faced Second Amendment challenges about the rights of gun purchasers or gun stores to force them to close. There are questions about whether it violates the free exercise clause of the Constitution to close churches. And then you have, the kinds of issues that Julie has been dealing with in various states about the constitutional right to abortion and whether the states can restrict or limit those rights. And one parallel I see with all of these issues, the gun issues, the church cases, the abortion cases, is that conservatives and liberals alike seem to be accusing each other of exploiting the crisis to take away rights that they don't like in the first place. So I thought it was interesting to see, like in Julie's case, I'm sure Julie will talk about this, reproductive rights groups see these red states as exploiting the crisis and going beyond what's necessary to protect public health. And the gun rights groups think that the same thing is happening with closures of gun stores and issuances of gun licenses. So that I think is really interesting, that we've kind of, in just a few weeks, we've replicated all of our culture wars and social issues through the lens of COVID. And then there's a whole other set of issues about what we do for the rights of people that are within the care of the state in some way. So prisoners in state and federal prisons are in a really vulnerable situation right now. People who might be about to be sentenced, immigrants who are in ICE detentions. We have more COVID cases now than any other country in the world, and we also have more prisoners. And states are, addressing those things in really different ways. So, those are just a few buckets of issues that I'm seeing, and it's really interesting to try to think about what the constitutional framework should be for dealing with those issues. That's not something we've confronted in many, many generations.
Julie, what's your view?
The work that I'm doing is, as Deepak said, focused on reproductive rights in this time. I think, at least as to those issues, I like the examples that you gave, Deepak, or description of sort of we've recreated all the culture wars, but in the lens of COVID-19. I mean, I think, just in the past year and a half, certainly we have seen states passing all manner of restrictions on abortions, from targeted restrictions on abortion providers to outright bans on abortion very early in pregnancy. And at the time, we thought those were coming at a fast and furious pace. But certainly the past few weeks, what we have seen among states, I think is a continuation of an anti-abortion agenda, but is taking place in real time, very rapidly, and under the guise, I think, of state officials who are saying, look, it's an emergency. There's no time to consider the various interests at stake here, and are asking for very broad deference with respect to their police powers. So in the area of reproductive rights, we have seen, many states at this point have executive orders, or governors have issued proclamations that prohibit health professionals from offering certain non-essential surgeries and procedures during the crisis. And, these orders vary in scope and their language, but they're generally framed as a way to save hospital capacity. If, for example, if you have someone who could have had a plastic surgery scheduled and that's postponed, and they can do that safely, that's one fewer person that you would have in the hospital. One fewer surgery that people, either physicians, nurses, other healthcare workers, are going to have to use gloves and masks, other items in short supply. So you can understand why states would adopt these orders, and in many states, our affiliates are complying with those orders as to the extent that they apply to them. But what we have seen is that a number of states have used these orders, general orders, and have interpreted them in a way that really ratchets up the restriction on abortion providers specifically. So in Texas, for example, the state adopted one of these orders on surgeries and procedures, which on its face applies to health professionals generally. But the following day, the Attorney General issued a press release with, in the title saying that something to the effect of the order applying to abortion providers, abortion providers, were targeted by name 3 separate times in the press release and threatened with the full force of the law if they violated the executive order by continuing to perform abortions. So, you know, I do think in the context of the reproductive rights cases, I do think there is a very clear line between the anti-abortion agendas that states were pushing before the crisis and what they have done using these general orders, which in some states are operating without problem for our affiliates, but using them in other states to really target abortion providers and the patients who.
I'm wondering if you would tell us what the current status is of that Texas case, and what do you think the future holds for other states?
Sure. So currently we have 8 cases pending against different states based on these orders. So it's not just Texas, although Texas was the first to be filed, and as interpreted, has been interpreted in the most restrictive way in the country. So state officials in Texas have argued that the order not only would bar procedural abortions, but would even bar medication abortions. You know, for those of you who aren't familiar with the terminology, those are abortions that they involve the ingestion of a medication. So it's not something where you would go into an operating room. I mean, most procedural abortions are done in an outpatient setting anyway, but particularly for medication abortions, it's just the ingestion of a pill. You go to a doctor and the doctor gives you a pill. So Texas has taken the position that even those abortions are prohibited by an executive order targeting on its face surgeries and procedures that might use protective equipment. So Texas is one of those states, but there are many others that have already been involved in litigation, either you know, on behalf of Planned Parenthood providers, but there are many independent abortion providers and attorneys working with them as well. So in the Texas case, currently we have litigation briefing ongoing in both the Fifth Circuit and in the federal district court in Texas. You know, what has happened in the Texas case, as is true in the other cases that have been brought, is that the trial court had issued a temporary restraining order to make sure that, you know, abortion access was preserved during this time. In some other states, the states subject to those orders have taken them up on appeal, and appellate courts have thus far dismissed the appeals. So access has been preserved in those states. But in Texas, unfortunately, both times we have gotten a temporary restraining order from the trial court. Once the order was quite broad, and then the second time a more narrowly targeted temporary restraining order. The state has taken an appeal to the Fifth Circuit of those temporary restraining orders and actually sought, for the lawyers among you, what's called a petition for writ of mandamus, which is an extraordinary remedy that is very rarely granted. But the Fifth Circuit, as to the first appeal, did end up reversing the trial judge, and there's currently another appeal pending. So in practice, what that has meant for our providers on the ground is that since March 23rd, they have been forced to turn away patients seeking abortion care, except for a couple of 24-hour periods when temporary restraining orders were in effect. That we've gotten a little more leeway to provide medication abortion this week because of some twists and turns in litigation, and to provide abortion to people who are about ready to hit the legal limit to even have an abortion in the state of Texas. But you know, the bottom line is the situation there is extremely dire for patients, and hundreds of them have been turned away just in the past few weeks, either to continue a pregnancy that they wish to end, or to travel to other states, sometimes flying as far as Colorado or Georgia to get an abortion.
Well, Julie, we are so glad to have you and Planned Parenthood and other groups fighting the good fight. Deepak, we just recently saw what the Supreme Court did in the voting case in Wisconsin. And we see all these Trump appointees on district courts, courts of appeal, and certainly 2 on the Supreme Court. How confident are you that we can rely on our courts to check assaults on our rights while we fight the pandemic? Do you have much confidence in our courts?
Well, I sort of have to because, for some of these issues, we don't have anything else. I mean, we need courts in order to provide, the one branch of government that's going to check, states and the federal government when they trample on constitutional rights. And, I think Julie's litigation shows what happens. I mean, you had district court issuing injunctions. Those were then, reversed very quickly in the Fifth Circuit, and I think you had a pretty conservative panel there. I don't know if Julie, if you want to speak to it, but it looks like you made a strategic decision not to seek all the Supreme Court review you maybe could have because you weren't sure you would get a favorable forum in the Supreme Court. And similar things have been happening on these other issues. So I mentioned there have been challenges by churches. There was one case in Kentucky that produced an opinion over the weekend. There's a really interesting opinion. It's written by Justin Walker, who is Donald Trump and Mitch McConnell's choice to be the next nominee on the D.C. Circuit. And the opinion, reasonable people can differ about the outcome of this case, which involved a church that wanted to perform, wanted to conduct its services, wanted to have people stay in their cars. There's a dispute about whether the city in Kentucky was even prohibiting that service, but the opinion read like a really partisan screed. And in the Wisconsin case, you had a very sharply divided Supreme Court, dividing 5-4 on the sort of usual partisan, political lines, and it honestly reminded me of Bush versus Gore, which as a litigator makes you feel sick because we can't do this work unless we believe that there is such a thing as law that can be kept separate from partisan politics. So, there's some signs of reasons to be optimistic that the courts are going to do the right thing on a variety of issues. Some of the courts have been, really solicitous of the rights of prisoners who are in a really vulnerable situation right now and are doing some unusual things to ensure that prisoners are safe. But I don't know how to answer that question, Nan. I mean, I wish I were more confident. And maybe there'll be a change in November and there'll be appointments that shift the direction of the court in a really different direction. But just before we got on this call, Donald Trump was at the White House and said that he would invoke his power to adjourn Congress in order to allow for recess appointments. So
yeah, what do you both think about that?
It sounds crazy to me. That's not how it works. I mean, recess appointments are supposed to be when Congress is legitimately on recess, but there is a provision in the Constitution that contains an adjournment power. Nobody really knows what it is or how it can be used. And it shows that in this extraordinary moment, the president is making really extraordinary claims. And, I think some of these claims, they have to be tested in the courts because there's no other place for them to be tested.
Yes, people are apparently outraged with his comment at Trump's comment at the press conference. Just want to remind everyone that we're going to conclude tonight with a question and answer session, so please email your questions to rachel@afj.org. Also, Deepak wanted to ask you about the gun industry. we certainly see some businesses, like local restaurants, going above and beyond to keep their employees and the public safe, but others are exploiting the crisis to build their own power. Deepak, tell us a little bit more about how the gun industry is using the guise of COVID-19 to strengthen their industry.
Yeah, so what we've seen is a number of challenges around the country where you have general orders that close, require that businesses close unless they're deemed essential, right? And so, and we've probably all seen this in our communities. We have, grocery stores, things that people need are going to stay open, but everything else is going to close. And the gun stores and gun rights groups have objected to local governments not including gun stores among the essential businesses. And, from their point of view, that cuts off their ability to access a constitutional right, which is the right to, to acquire and obtain and use a gun. And so you've seen Second Amendment challenges brought, several of them in California. The earliest one was in Pennsylvania. There's also a challenge now in Georgia where gun rights groups are claiming that the issuance of gun carry licenses is an essential function. And so if the state doesn't have employees in its offices issuing carry licenses right now, that is a violation of Second Amendment rights. And, I mentioned that I thought there's a kind of a similar structure to these cases and the cases involving churches and perhaps even the abortion cases. And I think, one way to look at these cases is, are these generally applicable rules that the states are laying down? If they're laying down a general rule in the name of public health, and they're not targeting constitutional rights, then that, one way of thinking about this is that should be permissible. And I think that's a useful way to think about all of these cases. Julie mentioned that you had these orders, and as I understand, she knows this much better than I do, but it sounds like similar orders are being interpreted very differently by states based on their view of the underlying issue and where they were before the pandemic. And you could analyze these other issues the same way. In the Fifth Circuit, in Julie's case, and this has come up in one of the church cases also, the courts are citing this case called Jacobson versus Massachusetts that was about vaccination law in Massachusetts during the smallpox epidemic, and somebody was objecting to that vaccination law. And the Fifth Circuit seemed to think that creates some kind of some kind of special constitutional framework for times of pandemic. I'm not sure I picked up the case and read it. It's not a case I had read before, and I don't really see that in the case. It just seems to say that states have police power. They can use that power to protect the public health, but they can't trample on constitutional rights arbitrarily. And I think we already kind of knew all that, so I'm not sure that it really provides much of a framework as the Fifth Circuit says it does. But I think this idea of general applicability is like a useful framework. And we already have that framework in the religion context. So, if a law passes across the board and substantially burdens someone's religious exercise, the courts are going to allow that because otherwise it would be anarchy. Everyone would be able to object to a law simply because they didn't agree with it. And I suspect that maybe the courts will start to coalesce around a framework like that. And I think that would help in the gun cases, but it might apply across the board.
Thank you. Thank you. This is one for both of you, really. Julie, maybe you first. How do we stay vigilant after this crisis is over? How do we stay vigilant to ensure our values aren't permanently discarded? What would you say we do?
Well, I think that the one of the lessons for me, and I think others living through this experience is that particularly during a time of crisis, you are going to see states asserting and the federal government asserting extraordinarily broad powers, and doing so to shut down opposition in the name of efficiency and speed. And so I do think that there will be room after this is over, or at least, is less intense than it is now, to reflect on that further and think about, how would we handle these kinds of assaults on rights in the event of emergencies going forward. I think what has happened this time, people are springing into action to fend off some of these attempts by state governments, but it is taking a lot during a time when, people are already very, very pressed. As to Deepak's point about the courts, I think this is certainly not the only experience that would underscore this, but I think what is happening in the courts and what will, may continue to happen with respect to assaults on civil liberties and during this time is, just another signal that courts matter and who is on the court and how courts are deciding issues are going to have really broad impacts. What in the reproductive rights field, for example, I think there is a lot of talk and concern, and rightly so, with respect to whether going forward the Supreme Court will continue to safeguard Roe v. Wade and progeny that have protected people's rights to have abortions. That's an important question, but I think that oftentimes people are missing that what's happening, particularly in the lower courts, may well take abortion out of reach for many people, even if Roe v. Wade remains on the books just as it is today. And so, the reality is abortion access depends, and I think, will continue to depend in part on where you live. And part of that, although not all of it, is based on, the way that courts are deciding cases involving abortion rights in those jurisdictions.
Deepak, what's your view of how we stay vigilant?
Well, I kind of ask myself that every day right now. And I think in some ways maybe we've got a little bit of training already, because the world, after November 2016 and after January 2017 started to look really different. And we started to have conversations with ourselves about how things that were happening were not normal, right? And this administration has already presented a just unprecedented number of threats to the constitutional order that I think, people of good faith of all different perspectives all kind of took for granted, right? We are used to living in a moment right now that represents a real threat to the rule of law, and where, if you just think back to the person you were and the things you thought were normal before Trump came around, that was a very different world. And I think this is just a very, very accelerated form of that, this pandemic. I know I've talked to a lot of friends who feel that their experience of time has actually changed over the last few weeks. Everything kind of blurs together, and certainly, as I said at the outset, our relationship to the government, the relationship to the state, and the kinds of things that the government can do has completely changed. And so I think, we've already had some training about how to stay vigilant. One thing is to try to remember what's normal and what's not. Try to remember what expectations we have and what is legitimately within the social contract and what isn't. And then, we have to continue to fight. And, I think, the work that Alliance for Justice does on the courts is essential. And a moment like this shows us that is the case, because in a really short amount of time, everything is on the table, including whether or not we can even have elections, whether we can have a functional democracy. I think this Wisconsin case it should scare everyone. It's true that the liberal justice won in the Wisconsin Supreme Court, and that was a remarkable thing. But look at all of the efforts that were undertaken to try to prevent a fair election. And I think this is just the beginning. I mean, there are going to be there's going to be a level of election litigation, like nothing people have seen before. There's a consent decree that's no longer in effect that prevented a lot of disenfranchisement tactics. And so people are going to have to be vigilant because, the very sort of viability of the democracy is at stake.
Absolutely. Well, certainly that Wisconsin case was not a great victory for democracy, although the outcome, as you said, was very positive. Deepak, I have a follow-up question sent in by Bill Yeomans, who I should let everyone know, whose provocative columns appear on our website all the time, and they're wonderful reading. He says on April 10th, there was an article in the New York Times entitled, "Trump has emergency power we aren't allowed to know about." And the article noted that Trump has powers in emergencies like the pandemic set forth in classified documents known as, quote, presidential emergency action documents, close quote. Because these documents aren't public, neither Congress nor the public really knows the full extent of Trump's power. As a litigator, Deepak, can you think of a successful litigation route to uncover these documents or powers?
Wow. Bill, that's an amazing question, and I hadn't read this article. I just Googled it while Nan was talking about it. That is alarming. I mean, the idea that I don't know about these documents, so I want to be careful. But it sounds like there are classified documents, and the idea of secret law is an anathema to our traditions. I mean, you don't. This isn't a republic where you have the Roman emperor who puts the laws high up on a column so nobody can read them. And there have been cases about secret law, much less sort of consequential than this. And I think the courts are rightly very skeptical. So, we should talk. That sounds like something that would be definitely worth exploring and possibly worth litigating.
I would say so. We also got a question as to the Democrats in the Senate. And Julie, this might be one for you. I know that Planned Parenthood has really been on the front lines of fighting for good judges and trying to keep dangerous ones off the bench. You think Democrats could do more, even considering the math in the Senate where they need to pick up 4 Republicans? Can you think of other ways or any ways how they should be fighting more aggressively to protect our courts?
Gosh, well, so, I should say the work that I do for Planned Parenthood really is focused on litigation. And here lately, that has been more than enough for us. I know certainly, Planned Parenthood, both the C3 that I work for and, our other affiliated entities are interested in these issues, but it's not really an area that I work on.
Certainly, I think Democrats have been going down to the floor and speaking up at Judiciary Committee hearings about the dangers inherent in so many of these appointees. I guess we need to continue to push hard, pressure both parties, let people know in certain states where educate voters in states around the country about really how bad and unqualified so many of these candidates are. And we will continue to do that, as well as so many other groups. Deepak, you mentioned the Wisconsin case, which I know is on the minds of most of us these days. Speak a little bit more about what you see as happening in the future with respect to voter suppression, cases coming before the Supreme Court. So many people have compared what the Supreme Court did in Wisconsin to, as you say, Bush versus Gore. How do you see this playing out over the next several months?
Well, I think there's going to be a really pitched battle over the degree to which people are going to be able to vote by mail, for example, whether or not we're really going to be able to conduct, free and fair elections. And that comes against the backdrop of a whole lot of fights that were going to happen anyway. Even if we didn't have a pandemic, we were going to have an unprecedented level of election litigation this year because of the consent decree that's out the window, as I mentioned, and just the toolbox of, voter ID. I mean, voter ID laws have amazingly been passed and enacted during this pandemic. So, the people who are architects of vote suppression are not letting up. They're doing all the things that they were going to do anyway, and then they're also exploiting the pandemic to make it difficult to vote. Just today, in Texas, we had the Texas Attorney General claim that anyone who tried to sign people up for absentee voting and told them that fear of getting COVID would be a good reason to vote by mail could be prosecuted for that activity. And then just a few hours later, a court in Texas, in a case brought by the ACLU, issued an injunction that's going to permit people across the board who are afraid of contracting the virus to be able to vote by mail. So that's just one example. In the Wisconsin case, you had a similar fight about what it really came down to was postmarks. Whether or not votes that were postmarked later on would be counted. And what the Supreme Court did was pretty gratuitous. I mean, there was an injunction that was in effect. People understood what the rules were going into the election. It had been affirmed by the lower court, and the court could have just done nothing. But instead, it intervened, and on the eve of the election, threw everything into chaos, and forced people, as the dissenting justices said, forced people to choose between their health and exercising their constitutional right to vote. That's not a choice that anyone should have to make. And so I think ultimately that's the question that is going to be litigated in courts around the country. Are we going to force people to make that choice?
And I certainly think our Chief Justice, John Roberts, has shown that he is not a standing up for voting rights in this country, but perhaps just the opposite. Say a little bit more about our Chief Justice on the issue of voting rights. Well,
what's interesting, Nan, I've just been reading Joan Biskupic's biography of the chief. That's my pandemic reading this weekend, and I was reading about his time in the White House. And in the Reagan and Bush administrations, and I think I already knew this, but the biography really hits home how much fighting the Voting Rights Act and fighting the architecture of voting rights is really something that he cut his teeth on early in his career and cares a lot about. And so people see the Chief Justice as a swing vote sometimes, as moderating his conservative politics in cases like the Affordable Care Act case. When it comes right down to it on issues of voting and race, he is unyielding. He's an unyielding foot soldier in the conservative legal movement.
Yeah, I think that's right. And certainly the two newest justices, Kavanaugh and Gorsuch, are probably right there with him. Julie, or Deepak, did you want to comment on those two? Any?
Yeah, just one other thing, which is, Linda Greenhouse had a fantastic column recently about the Wisconsin case, and she was maybe even more outraged than I was, and I was pretty outraged that day when it came out. I did not think that there were reasonable arguments for the court's position. She also said it, reminded her of Bush versus Gore, and I think what it shows is, the court is just willing to invest political capital in a case like this, willing to have the public see that it's a 5-4 decision that breaks down on party lines, which is, nothing is more damaging to the court's institutional credibility than a vote like that in a case about, a pending election. And yet the court is willing to go there. So for those who think that, the Chief Justice and perhaps Justice Kavanaugh care about the court's institutional credibility, at least on issues like this, that is not a constraint.
Yep, absolutely. Julie, last one for you. Could you discuss the case that's pending before the Supreme Court? I think it's June Medical versus Russo. Can you tell us a little bit more about that case and what you think will happen?
Yeah, well, certainly what we hope will happen is that the court will come out on the side of providers in this case, which is virtually identical in terms of the law at issue to a case that the Supreme Court just heard a few years ago in a case called Whole Woman's Health, and in that case sided with the providers in a 5-4 decision. The law in the case currently pending before the Supreme Court is out of Louisiana. It's a law that, as many conservative anti-abortion states have passed, it's a law that requires doctors to have admitting privileges at local hospitals. The reality of these kinds of requirements for admitting privileges is that they don't have a credentialing effect. They're not really designed to identify doctors who are capable of providing good care. And at the same time, they make it extremely difficult, if not impossible, for doctors who practice and work in places where hostility to the provision of abortion runs really high. So that's what we saw in Texas a few years ago with the law that was at issue in Whole Woman's Health. The state of Texas had passed a number of targeted restrictions on abortion providers that had the effect of closing more than half of the clinics, I believe, in the state, many of which never reopened. And so at this point, the situation, as I understand it in Louisiana, we're not involved as a party in that case, but as I understand it, the stakes are equally, if not equally high, if not greater, in the sense that if the state is allowed to require admitting privileges for physicians, as it is attempting to do, it will force, more closures and much greater distances for patients to travel to see an abortion provider. So the issue before the court is whether that kind of restriction imposes an undue burden on patients seeking an abortion. The court also, in a concerning sign when it granted cert review in that case, also granted a cross petition from the state challenging what's called third-party standing of abortion providers to bring suit on behalf of their patients. That the doctrine that has allowed abortion providers to bring suit to vindicate their patients' constitutional rights is longstanding. It has been reaffirmed for decades. And this is, I think, a new front in the war on abortion to take on the idea that abortion providers could go to court and protect their patients' rights, and instead try to force patients one by one to resort to the courts. So, the stakes could not be higher, but we think, and I know certainly the parties, the way that this has been briefed by the providers in that case, think that there's very clear precedent on point. The court just decided a case nearly identical to this one several years ago, and if it follows its precedent, it should come out in the same way.
Thank you. And last question for Deepak. Shelby County, which you mentioned, that decision gave licenses, we know, to rampant voter suppression. Congress could pass, couldn't it, new policies to give teeth to the Voting Rights Act again?
Well, it could, but Shelby County is a constitutionally based decision, and so it limits Congress's ability. It can't just sort of reenact, Section 5 of the Voting Rights Act. And what that did is it dismantled and took away a lot of the teeth from the voting rights section to pre-clear changes in voting rights. So you had a whole setup in the Justice Department that would do this, and instead now what that's meant is that people have to litigate these cases under what's called Section 2 of the Voting Rights Act. But that's happening, and I think the encouraging thing is that there's a whole army of lawyers that have been set up to bring these challenges. And as I mentioned, the case today in Texas, that victory, there are ways under the existing framework to fight back. It's not that sometimes I think in the popular press people think, oh well, the Voting Rights Act is gone. The Voting Rights Act isn't gone. The provision that allows you to bring these cases in court is still there, and it's still being enforced every day. So I think that's really where the efforts are going to be in the current environment from now until November, is pushing back on disenfranchisement efforts, making sure that people are going to be able to exercise their right to vote, however they're able to do that in a public health situation that may not allow ordinary in-person voting.
Well, thank you both so much for spending some time with all of us this evening. We're so grateful for your work, and we're proud that you both are really at the forefront of such important litigation and leading the legal resistance. So thank you both for your work, and thank you for being here tonight and providing such insightful words and comments. And thank you all for joining us. We will be back in touch with you with information as to our next program, which will take place in a week or so. We will send out emails, and we really so much enjoyed having everyone join us this evening. And Deepak and Julie, you guys were terrific. Thank you.